Commission on Environmental Quality to order. Today is October 31st, 2018. Happy Halloween. Time is 9:30. With us today are Commissioner Emily Lindley, and for our General Counsel's Office, Tracy Gross, and I'll ask Ms. Gross to begin the proceedings.
Good morning. Item number 1 is consideration of the ALJ's proposal for decision and proposed order concerning an enforcement action against Landed One Limited, DBA J.H. Walker Trucking. The parties have been notified that they have 5 minutes of oral argument time, with the ED beginning, followed by the respondent and OPIC. The ED may save some of his time for rebuttal as he bears the burden of proof.
Good morning.
Good morning. Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Adam Taylor with the Litigation Division, representing the ED. With me today is Joaquin Garcia, an investigator with UTA, and Epi Villarreal of the Enforcement Division. This case involves 2 violations of the petroleum storage tank rules at a facility owned and operated by Landed One Limited. During an investigation conducted on April 20th, 2017, Mr. Garcia documented that respondent failed to renew a previously issued delivery certificate and accepted a fuel delivery without a valid current delivery certificate. On June 18th, 2018, the ALJ held an evidentiary hearing on the merits, which concluded on the same day. On August 9th, 2018, the ALJ submitted her proposal for decision, in which she found that respondent committed the violations. Specifically, respondent did not have a valid current delivery certificate between January 31st, 2015 and May 25th, 2017, and respondent accepted fuel deliveries during that time. The ALJ also found that the administrative penalty was calculated appropriately and in accordance with the penalty policy. The ALJ recommended a respondent pay the assessed administrative penalty of $3,157. The ED filed minor exceptions to the ALJ's proposed order, which she recommended sustaining in whole. The ED concurs with the ALJ and recommends adoption of the order. We are here to answer any questions you may have, and I'd like to save the remainder of my time for rebuttal if necessary.
Thank you. Commissioner Lindley, any questions?
No questions.
Mr. Walker, are you present? Morning, sir.
Morning.
Might
I'm
check-
excuse
I
me.
was going to say, you might check the mic, make sure it's turned on. Sounds like it is, though.
Yeah, I'm kind of a little jealous. For the last 7 years, I've been on the Department of Motor Vehicle Board and as chairman, and our facilities aren't quite as nice as y'all's are over here, so I needed to go see the governor. Maybe I should have visited before today, so I could have had a better argument. I'm here today to talk to you about what the circumstances are surrounding the penalty that was issued. Am I going to say that we were in violation or contra to what he might have said, that we didn't violate the law? We probably did. But what happened is that as an agency of the state of Texas, it's part of your responsibility to see that the citizenry of this state gets notified of renewals. Operating a business today, and I operate several businesses in the state, we probably have over 50 agencies, municipalities, cities, states, and counties that want us to permit. It's gotten so ridiculous today running my business that the city of Houston requires us to pay $300 for a garbage permit to have a garbage can. We have to have a $300 permit to have a dispensing permit in the city of Houston to dispense the fuel that you're regulating through your agency. Department of Agriculture makes sure that I have a weights and measure ticket on that pump to make sure that it facilitates that I'm giving the right amount of fuel out, even though I'm dispensing the fuel to my own trucks. It's not like I could cheat myself. But I could go on and on about all the permits. What happened in this situation here, and you look at the record of our company, we've been in business for 40 years. We've operated above board, always paid our fees. This delivery certificate that you're asking me about today is a delivery certificate is nothing more than a self-certification. You send out a form that says, do I certify that my tank is still there and underground and that it meets the compliance within the state's regulations? Yes, my tanks were there. Yes, we do use them. We did not get a renewal certificate from the agency here. It never came to us. It did not even come this year because of this action that was brought about. I had to call your agency, ask that you send me a certificate of a renewal on it, and that's so. The man right here that in the testimony at the hearing that we had at the AOL decision, he said, it's not our responsibility, Mr. Walker, to notify you of when your agency. It is your responsibility to renew. I don't believe that to be right. I don't think that's the way state government needs to work in the state. I sure know, as a head of a department of one of the largest agencies in the state of Texas at the DMV, we never wanted to treat the citizenry of the state of Texas as if they were criminals and crooks. Our system has worked. We have had those permits. If you want to go and carry the extent of the law out, the law and the rule says that you have to take the delivering carrier who delivers the fuel to my office is also in violation. So every load that was delivered for the entire year, you could have gone back and fined every one of those, but they said, well, we only caught you. Let me tell you about the circumstances surrounding this inspection. It was not where you took and said, we got you. I personally called and requested this inspection of our facility because we did a recertification of our tanks due to our vapor recovery system that has been a mass failure out there, which I think your agency realizes. It has gone in, and because of the vapor recovery systems from the pumps, it's pushing that fumes back into our piping systems, causing them to corrode. We had to go in there and replace all that. To correct that, we had to remove the vapor recovery system and take it. To do that, once we did that, we had to recertify the tanks. I promise you, my tanks don't leak. I promise you that we monitor our system on a daily basis. We have the most sophisticated system. We have double-walled tanks. We have alarm bells on there that tell us if that system is failing. It tells us that if we put in 1,000 gallons and 10 gallons are coming out of there, if that tank doesn't monitor the 10 gallons that came out of that pump, it shuts our system down, warns us that we have a failure in our system. We have monitors that monitor the water contents in our fuel and everything. We have the best that money can possibly buy today to protect the environment at our company. So then he comes out here, certifies everything else is right, and he says before on his exit, I need to see a copy of your delivery certificate receipt. We didn't have one because it came the next day. We had recertified our pumps. The certificate came in the next day after he left because we had found out that it wasn't there. We requested a new one. What really upset me more than anything that brought me here today was I got a letter from you a month later, maybe 2 months later, and it said that, hey, you're in violation of not having a delivery certificate at your facility. We want $5,600 from you. But we'll cut a deal with you today. If you pay us today, it's let's make a deal for $4,600. We'll lower the fine to entice me to pay. That's not the way state government works in the state of Texas. That's not the way the legislators want to operate. That's not the way the governor wants to operate. I know these people.
That's 5 minutes.
I'd ask you just to take a few more seconds and wrap it up, Mr. Walker.
Okay. I'll wrap it up right now. I'm just telling you that a $4,800 fine to somebody that doesn't have a certificate, that was something that we self-certified, that we just mail in. There's not even a fee associated with it. It just says, here, yes, we have that tank, and mail it to you. It's not something we intentionally did. It's something that was accidental, that we didn't, either the mail service didn't get to us, either you didn't mail it to us, or maybe it comes in today, we get 80% of our mail, it looks like trash, and maybe somebody that sorts our mail threw it in the trash can. Thank you very much for your time. I appreciate it. I'd like you to reconsider the decision is so, because I don't think it's a just decision. I don't think $4,800 is a fair penalty for a business person, and the financial burden you put on companies is absolutely ridiculous at that level. Thank you very much for your time, gentlemen.
Thank you, Mr. Walker. I'm certainly sensitive. You can go ahead and take a seat, sir. Certainly sensitive to your concerns about the burdens of regulation, and I'll have some thoughts on some of your other comments in a moment. Commissioner Lindley, did you have any questions or comments at this point?
Not at this point.
Okay.
Not at this point.
Mr. McWhorter.
OPIC agrees with the analysis of the administrative law judge and the executive director. We recommend approval of the proposal for decision with the modifications laid out in the executive director's exceptions. Aaron Tucker is here with me today. He represented OPIC at the hearing, and we're available if you have any questions for us.
Thank you. Any questions?
No, thank you.
Mr. Walker, I appreciate your frustration. I understand that you're playing by the rules. Our investigator was there at your invitation. That is a a legal requirement for decommissioning, but still you were abiding by that. General Counsel just let me know. I didn't afford the executive director an opportunity for rebuttal, so let me pause on my remarks and offer you that opportunity.
You have 3 minutes and 30 seconds remaining.
Thank you, Chairman. I'd like to first point out that evidence of settlement offer is not part of the record before the commission today. The rules do require the owner renew their delivery certificate on time. The ALJ did conclude that they failed to do this and that the administrative penalty was calculated appropriately and in accordance with the penalty policy. Thank you.
Thank you. Again, I'm sensitive to your situation. Yeah, again, the investigator was there at your invitation. You did not receive a renewal reminder for the delivery certificate, or so it would seem. And the penalty amount, I agree, is not trivial. So it appears to me that this began as an honest mistake. Our challenge with the PST program is that these tanks, not yours in particular, but as a general proposition, these tanks pose a real environmental risk, and there are a lot of them in the state of Texas. So our program is built really around this fuel delivery certificate. That's how we inventory and control these tanks, and it's really how we manage this environmental risk. And the delivery certificate is more than just a piece of paper. It is, as I explained, central to how the program operates, and it's really a license to operate. So it's more akin to a driver's license in my mind than it is to a vehicle registration. And the executive director is correct when the executive director points out that our rules and our guidance put the obligation on the owner or operator of the tank to timely submit a renewal application, whether or not a courtesy reminder is mailed out. And the tank at issue here, there's no dispute that it did not have a delivery certificate for over 2 years. And because that certificate is so central to our programs, it's difficult for us to let that slide without creating a real problem for the agency in our efforts to promote compliance. And I'm sensitive to the fact that you're an above board operator, that your tanks are satisfying the requirements, and that you really are making the effort to do that. But it puts us in a difficult situation. And so while I'm sympathetic to your situation, Mr. Walker, I have to support the ALJ's recommendation here. Let me comment on the penalty too. As I said, it's not trivial. It is, however, about as low as a penalty could be under our penalty policy. And if we start to deviate from our penalty policy, that also creates problems for us in our compliance and enforcement efforts. So now, concerns about the renewal notice. I think it's true, as staff indicated during the hearing, and as I just mentioned, that the onus is on the owner or operator. As a legal matter, we aren't required to send out that notice, and the obligation falls to the owner or operator. As a customer service matter, in terms of how this agency serves the people of Texas, that does matter to me, and it's important. And so, separate and apart from the enforcement issue that's before us today, I'm going to ask program staff to prepare a memo that outlines what our policies are, what our practices are, if there's any daylight between the two, and also to suggest any improvements to the renewal notice process or practices, if there are any, while being sensitive to the costs. And I'd ask for that within 2 weeks. But in terms of the matter before us, it's going to be my position and my suggestion that we go ahead and adopt the ALJ's proposal for decision. And Commissioner Lindley, I've been monopolizing the conversation.
That's fine.
What are your thoughts?
Exactly those. The only thing I was going to comment and say is that I agree that it is the responsibility of the owner to renew. However, this case is brought to light maybe that we need to look into. Is there some sort of reminder system we need to put in place? And I appreciate that Mr. Walker pointed that out because we do want to provide good customer service. But where this is right now and when the violation occurred, there was a violation. And so I'm comfortable adopting the ALG's proposal today.
I'll entertain a motion.
Okay, I move that the commission adopt the ALJ's proposed order with the modifications recommended by the ED's exceptions and agreed to by the ALJ's reply, but utilize the capitalization of the respondent's corporate name as provided in the ED PRP.
The motion has been made. I second it. All those in favor?
Aye.
Aye. Motion carries.
Item number 2 is a non-House Bill 801 hearing request concerning the application by San Jacinto River Authority for water use permit number 13183. The parties have been notified that the commission will not take oral argument, but may ask questions. And you have Carolyn Ahrens with the City of Conroe and Nathan Vassar representing San Jacinto River Authority in case the commission has questions.
Thank you. Commissioner Lindley, as I look at this, it's apparent to me that the City of Houston has demonstrated a personal justiciable interest, almost just by nature of holding their water rights
I would agree.
down the water course, and they also point to concerns about impacts on their citizens and the health of Galveston Bay. I think the applicant urges a hyper-technical reading of those requirements, which really sort of would distort them. And so I'm eager to hear your thoughts.
I would agree. I think this one's pretty straightforward. So I'm ready. I'll do a motion if you're ready.
I am.
Okay. I move that we grant the hearing request to the City of Houston and refer the matter to the State Office of Administrative Hearings to conduct a contested case hearing.
The motion has been made. I second it. All those in favor?
Aye.
Aye. Motion carries.
Item number 3 is consideration of the adoption of the renewal with amendments of the livestock manure compost general permit number WQG200000, which authorizes the disposal of wastewater by evaporation or beneficial irrigation adjacent to water in the state.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Laurie Fleet with the Water Quality Division. With me today is Shay Pearson with the Environmental Law Division. Staff request adoption of the renewal with amendment of a state-only general permit number WQG 200,000, which authorizes the disposal of wastewater by evaporation or beneficial irrigation adjacent to water in the state from livestock manure compost operations. The renewal with amendment will replace the current permit when it expires on November 10th, 2018. Public notice of the draft permit was published in the Dallas Morning News, the Fort Worth Star-Telegram, the Stephenville Empire Tribune, the Waco Tribune-Herald, Amarillo Globe News, and the Texas Register in June 2018. The public comment period ended on July 9th, 2018, and no public comments were received. Staff recommends adoption of the general permit and requests authorization to make non-substantive revisions to comply with Texas Register formats. Thank you. We're available for any questions.
Thank you. Any questions?
No questions.
Mr. McWhorter?
OPIC recommends adoption of the renewal and amendment of this general permit as presented by the Executive Director.
Thank you. I agree. This is a non-controversial renewal with only minor amendments, so
I agree. Ready for motion?
I'll entertain a motion.
I move that the commission adopt the renewal with amendments to the livestock manure compost general permit number WQG200000.
The motion has been made. I second it. All those in favor?
Aye.
Motion carries. Thank you.
Item number 4 is consideration of a resolution to extend the existence of the Irrigator Advisory Council and appoint 3 members to serve on the council. We have ED staff approaching to lay this matter out.
Good morning.
Morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm James Hempel, the Program Support Section and the Office of Compliance and Enforcement. With me today is Alicia Ramirez, staff attorney with the Environmental Law Division, and Christy Mills-Jurok of the Program Support Section. We're here today to request the appointment of 3 members to the agency's Irrigator Advisory Council. If approved, these recommended appointees will receive 6-year terms that will expire on February 1st, 2025. The recommended appointees are Mr. David Moulton, irrigator from Mansfield, Mr. Charles Swanson, irrigator from the College Station, and Ms. Jennifer Walker, public member from Austin. Included in your backup material are resumes for each of the recommended appointees describing their background and qualifications for the appointments. In addition, we request that the commission extend the existence of the Irrigator Advisory Council to February 1st, 2025. Currently, the council is set to expire in February 2023. We're available to answer any questions if you have any on this matter.
Thank you. Any questions?
No questions.
Mr. McWhorter?
OPIC recommends approval of the resolution extending the existence of the Irrigators Advisory Council and appointing the 3 new members recommended by the Executive Director.
I agree with that. And let me say, too, that I really appreciate the support that the council provides our regulatory programs, and I appreciate as well the council members and our 3 nominees' time and talents towards the council's work. Always impressed by the experience and expertise that the council members bring, and that's the same is true for our 3 nominees. So I think it's appropriate that we move forward with this action.
I agree. Ready
I'll
for
entertain a motion.
Okay. I move that we adopt the Executive Director's recommended resolution extending the existence of the Irrigator Advisory Council until February 1st, 2025, and filling the vacancies on the Irrigator Advisory Council as follows. Appoint David Moulton, whose term shall be effective February 1st, 2019, for a 6-year term to expire February 1st, 2025. Appoint Charles Swanson, whose term shall be effective February 1st, 2019, for a 6-year term to expire February 1st, 2025. And appoint Jennifer Walker, whose term shall also be effective February 1st, 2019, for a 6-year term to expire February 1st, 2025.
The motion has been made. I second it. All those in favor?
Aye.
Motion carries. Thank you.
Thank you.
Item number 5 is consideration of material changes to contracts for goods or services awarded under Chapter 2155 of the Texas Government Code executed during the previous quarter. And we have ED staff here to lay this item out.
Good morning.
Good morning. Good morning, Mr. Chairman, Commissioner Lindley, General Counsel, and Public Interest Counsel. For the record, my name is Chris Goldberg, Procurements and Contracts Manager of the Financial Administration. I have with me Stephen Lang and Sergio Vasquez of the Financial Administration Division. We are representing the Executive Director. This item contains the material changes made to contracts and purchase orders for goods and services between June 1st, 2018 through August 31st, 2018. Reported material changes include extensions of contracts or completion of work for 6 months or more, or an increase in consideration of 10% or more, in accordance with Section 2155.088 of the Government Code. The Executive Director presents these items for your consideration.
Thank you. Questions for staff?
No questions.
Mr. McWhorter?
OPIC recommends approval of the resolution acknowledging the material changes to contracts for goods and services as presented by the Executive Director.
And I agree. I didn't find any issues in my review and think it's appropriate to
No,
move
you're-
forward.
Okay, I move that the commission approve issuance of the Executive Director's proposed resolution that acknowledges the material changes to the contracts for goods and services in accordance with Section 2155.088 of the Texas Government Code for the time period of June 1st, 2018 to August 31st, 2018, as described in the TCEQ Interoffice Memorandum to the Commissioners and Executive Director dated October 31st, 2018, and docket number 2018-1331-MIS.
The motion has been made. I second it. All those in favor?
Aye.
Motion carries. Thank
you.
you.
That takes us to the Commission's enforcement docket. Items 6 through 28. The Office of General Counsel has remanded item 22 on October 25th at the request of the Executive Director. The ED is here to present the remainder of the items. Have 2 individuals that have signed in to speak if we have questions on the city of Weslaco, and their affiliations and member or attendance will be noted for the record.
Thank you. Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I'm the Agenda Coordinator for the Litigation Division. With me today are Katanjali Yadav, also of the Litigation Division, and Brian Sinclair and Melissa Cordell of the Enforcement Division, representing the Executive Director. Pending before you are items 6 through 21 and 23 through 28. The total assessed administrative penalties are $302,067, with $51,383 deferred, $33,615 applied towards supplemental environmental projects, and $217,069 to the general revenue. The Executive Director respectfully requests approval of these items, and we're available to answer any questions you may have.
Thank you. Any questions?
No questions.
Mr. McWhirter?
My office reviewed these items, and we recommend approval of the proposed orders as presented by the Executive Director.
And I've reviewed these items as well. I think it's appropriate that we move forward and would entertain a motion.
Great. I move that the Commission adopt items 6 through 21 and 23 through 28 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor?
Aye.
Motion carries.
Item number 29 is consideration of the monthly enforcement report, and we have enforcement and litigation staff remaining to present this item to the Commission.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division and Gitanjali Yadav and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2018 through August. There are 1,370 effective administrative orders issued, and of those, 169 contain supplemental environmental projects. These orders assessed a total of $13,379,545 in penalties, with a payable amount of $7,523,529. $3,920,170 are to be paid toward supplemental environmental projects. 16,132 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,803 enforcement action referrals have been received. There are 1,563 pending administrative orders, with 122 cases that are on the backlog. 220 cases are pending at the Attorney General's office for representation in district court, and 34 judgments have been issued. 2,114 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2016, 17, and 18. We are available to answer any questions you may have.
Thank you. Any questions for staff?
No, not this time.
Mr. McWhirter?
I appreciate the report and all the hard work it represents by staff. I don't have any questions.
Likewise,
Likewise.
and no action is necessary on this item, so we thank you for the report.
Item number 30 is our rule matter, consideration of the adoption of amendments to 30 TAC Chapters 116 and 122 and corresponding revisions to the State Implementation Plan and Texas Federal Operating Permits Program. We have ED staff here to lay out this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Mike Wilhoit with the Air Permits Division. With me is Namasha Weliwedigoda of the Environmental Law Division. This rulemaking, if adopted, would revise Chapter 116, Control of Air Pollution by Permits for New Construction or Modification, and Chapter 122, Federal Operating Permits Program, to allow the Commission to provide certain permit-related notices using an electronic method as authorized by House Bill 4181 of the 85th Texas Legislature. In addition, the revisions also specify notification and registration requirements for changes at facilities authorized by air quality standard permits, clarify requirements for prevention of significant deterioration review of greenhouse gas emissions, clarify renewal requirements for plant-wide applicability limit permits, clarify requirements for federal operating permit compliance certifications, and make various other updates and revisions to sections in these chapters. If adopted, the revisions to Chapter 116 will be submitted to the United States Environmental Protection Agency as a revision to the State Implementation Plan, and the revisions to Chapter 122 will be submitted to the EPA as a revision to the Texas Federal Operating Permits Program. The proposed rules were published in the May 25, 2018 issue of the Texas Register. A public hearing was held on June 22, 2018. The public comment period closed on June 26, 2018. The rule team did receive public comments, and based on those comments, the rule team made the following substantive change. Withdrew the proposed change to Section 116, which would have deleted a reference to PAL permits in rule language defining the agency's permit review schedule. In conclusion, staff respectfully recommends adoption of the revisions to Chapter 116 and 122. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you. Any questions at this time?
No, yesterday, staff came over and briefed me at my request, because I felt like I had a lot of catching up to do because I wasn't here for proposal. And when I read in the backup that, there were going to be several amendments to chapters 116 and 122, which were unrelated to HB 41, I paused because that just makes me reread and want to dive further into what we're doing, because I just want to make sure we're not ever going past what the legislature has directed us to do. But staff briefed me, kind of answered the few little questions I had, gave me a better understanding of what this rule does, and so I feel comfortable moving forward today.
Mr. McWhorter, your thoughts?
OPIC recommends adoption of the amendments to the Commission's Chapter 116 and Chapter 122 rules as presented by the Executive Director.
And I agree with that as well, and I'd be happy to entertain a motion.
Okay, well, I will move that we adopt the amendments to 30 Texas Administrative Code, Chapters 116 and 122, and corresponding revisions to the State Implementation Plan and Texas Federal Operating Permits Program as recommended by the Executive Director.
The motion has been made. I second it. All those in favor?
Aye.
Aye. Motion carries. Thank you.
That takes us to the end of our open session. The commission will be meeting in closed session in Building E, Room 211S at, what time would you all like to meet?
Meet at 5 after.
5 after, at 10:05, as permitted by the Texas Open Meetings Act, Texas Government Code Sections 551.071 and 074, to take up and consider matters pursuant to items 31 through 34 as posted and noticed.
And with that, the time is 10:02. We stand in recess.
The commission met in room 211S, Building E, for closed session from 10:05 a.m. until 10:17 a.m. on item number 32 as posted and noticed pursuant to Texas Government Code 551.074. No action was taken. The commission did not meet on items 31, 33, or 34. The agenda stands adjourned. The time is 10:19.